We might get started to this workshop session. I won't add very much to what's already been said. I think that you want to hear from the participants. But as background, of course, what we have is a very wide-ranging review. I guess one of the issues is, did it capture everything? We're re-examining some issues and absolutely rehashing others. I'm going to say no more, but introduce you to Marina Nen.
Thank you. My presentation today is based on two papers that I have written with James Laman. The first one is an article that I published this year in the Australian Journal of Competition Law, and the second one is a submission to the Harper Review. Now, the focus of my presentation is on Section 46. As you know, this is the section about misuse of market power, and this is a very important section that does attract very strong feelings and perspectives. Certain people want it to disappear, no longer exist, vanish. Other people want it to stay the same, and other people want to revisit it and reform it to make it more efficient. I fall in the later category. So I do believe that Section 46 is very important. It needs to be changed to make it more effective and more efficient. Now, with Section 46, it has been amended a lot during the last, since it has been introduced, basically. And this section is, with every amendment, it doesn't necessarily get better. Sometimes reforms to Section 46 remind me of reforms to the Corporations and Financial Services Law. They are supposed to simplify and make the legislation more efficient. They don't necessarily do that. And one of the latest changes to Section 46 with the Birdsville Amendment was not the most efficient or effective provision, really, because the Birdsville Amendment is supposed to be dealing with predatory pricing. However, how efficient the provision is questionable. Now, Section 46 has received, the ACCC receives every year a number of complaints on Section 46. So I've taken here some of the data from the annual report of the ACCC. So you can see I just picked a decade from 2001 to 2011-12. There is 5,648 amendment to 5,648 complaints about it. And in certain years, the complaint regarding Section 46 is one of the most complained about sections. So there is lots of people complaining about potential breaches of Section 46. However, when you compare that with public enforcement of Section 46, you discover there is a big disparity. And the number is 18 cases that the ACCC has brought from 1974 to 2011. So the number is very small, especially when you compare it to 5,648 complaints. And that's only in a decade, while this is in almost 4 decades. And the question is, why is this number very low? Why is it only 18? Why isn't it more than that? The answer might be that the ACCC is being more, might be looking at Section 46 in a very conservative perspective and will only be bringing action regarding Section 46 if there is high chance of success. And as a result of that, we only have 18 cases. And when we are looking at these 18 cases, there is 11 of them that were successful by the ACCC, which again highlights that the ACCC may be bringing cases that they believe have high chances of success. And these 11 cases form 61.1% of success rate, basically. And they highlight that yes, you can actually enforce Section 46, but again, it is quite hard to do so at the same time because the number of cases is only 18. Now, also there is another trend which is entering into enforceable undertaking, and enforceable undertaking is a sanction available to the ACCC since 1993, and it allows the ACCC to enter into settlement with certain alleged offenders to deal with potential breaches of the law, one of them being, of course, Section 46. When you look at the enforceable undertaking numbers that dealt specifically with Section 46, you only see 13 of them. And that shows, again, that Section 46 is enforceable undertaking is not being used a lot in that area. And there is over 1,000 enforceable undertaking entered into by the ACCC. So this is really a small number, and almost half of them are in relation to competition law. So there is an issue with Section 46 enforcement-wise. And the question is, how can we motivate people to comply with Section 46? And the answer can be, for example, there is legitimacy and trust in authorities. Of course, people believe in the section, so they would comply with it. But from another perspective, if you're rational actors, then what you will be looking at is certain things, such as the term of the provision. Are they actually enforceable? If they are enforceable, if there is a high chance of me getting caught, if I do this, then probably I will comply with it more. Another one is the penalty regime that is applied. So if the penalties are high enough, then the people will comply with the section. And again, penalties by themselves are not enough, so you might have very high penalties, but they may not be effective. What is more important is that you can actually find that a breach of the section has actually occurred. So what I will be looking first at Section 46, the need to change. As I mentioned, I do believe Section 46 needs to be reformed. And the Harper Review is trying to do that in a simplified way. So the three key elements of Section 46, which you all know, are the defendant corporation has substantial market power, the defendant corporation has taken advantage of that market power, and the defendant corporation has used the power of an unlawful purpose as described under Section 46, 1A, B, or C. Now, with the first element, it's a very important element that needs to remain, of course, and that's what the Harper Review believes in, too. Now, the second element, the defendant corporation has taken advantage of that power. The Harper Review is proposing removing this element, which I actually support, because this element has been one of the controversial elements. So certain conduct may actually be lessening competition, but they don't fall under taking advantage of that power. And as a result of that, a breach of Section 46 will not be found. So as a result, removing this element may be actually quite useful. The last thing is the defendant corporation has used the power to an unlawful purpose. The unlawful purpose element is not necessarily the best one to actually deal with anti-competitive behavior, because you might not have this unlawful purpose, but you might actually, the effect of your conduct may be to limit or lessen competition. So as a result, there is a need to consider more than just the purpose, and there is a need to consider the effect test. I believe in the introduction of the effect test, even though it has been criticized heavily by other people, and a number of reviews into Section 46, basically 11 of the reviews that considered the effect test, 10 of them said we don't need it, it is not necessary, there is no evidence for why it should actually be introduced. Now, from my perspective, when you look at the number of complaints that the ACCC received and the number of actions that it has, and the way the court are interpreting Section 46, it highlights that the section is not effective. It's not. It's very hard to prove. Now, the effect test may make the section more effective. Now, so introducing the effect test will be a positive thing. Now, the Harper Review also discusses introducing defense. Now, that it's a rational business decision that is being made. It is a rational business decision that would be made by a corporation that does not have substantial market power. Now, that element of the defense, from my perspective, is a little bit confusing. I am not sure how it would be actually interpreted, and would it be viewed from an economic perspective? And if it's viewed from an economic perspective, are we looking at profitability of the choice, of the decision that is being made, the strategies that is being adopted by the corporation? Because there may be some decision that may be profitable, rational business decision, and they would be profitable, but they may not necessarily be legal and acceptable. So as a result, reviewing that element of the defense may be needed. The second part of the defense, talking about the long-term effect of the conduct on the competition. Would it actually positively improve competition in the long run and help consumer and protect the interests of consumers? I believe this is more than a defense. Section 46 itself should not just be looking at the short-term interests of the conduct. It should also take into account the long-term interests of a conduct on consumers, because there are certain decisions that are being made by different people that may actually be positive for competition in the short term, but for the long term they may not. They may raise certain costs for entering into the market and so on. And in that perspective, just considering the short-term interest is not good enough. The long-term perspective should also be embedded into Section 46 and not just as a defense. Now, that's looking at the effect test, so the provision, the terms of the provision itself. Now, assuming that the terms of the provisions have been changed and amended to make the provision more effective, more user-friendly from the perspective of the ACCC. Another thing that can be looked at is the penalty regime that applies. And I have put here the numbers of the cases that have been successful, so the 11 cases, and what are the penalties that have been imposed on the corporations that have brought the penalties that are imposed on the corporation. I have divided them into 3 categories because there is a change of the penalty amount that would be imposed. So from 1974 to 1992, the maximum penalty was $250,000. And this amount was not viewed as acceptable. It is too low. It does not have any deterrent effect because the benefit might be actually higher than, for a business, maybe higher than the penalty that would be imposed. So as a result, in 1993, we had an amendment to this, and the penalty went up to $10 million. In 2007, we had another amendment because $10 million was not viewed as acceptable, so we had between a highest amount of $10 million or 3 times the illegal gain, or if that can't be calculated, then we're looking at the turnover, 10% of the turnover of an organization. Now, the penalty purpose is deterrence, so we need to get the right balance there. And the question is, did we get the right balance in the latest amendment? And I am not sure if we have or we haven't, because when I'm looking at the amount of the penalties, the average, the highest penalties, and so on, and of course being mindful of the fact that there aren't many cases regarding this, it shows there is a reluctance by the judiciary to actually impose the highest amount. And that turns your mind to, okay, if you're not imposing the highest amount, which is not always appropriate because sometimes the highest amount should really be for more serious, egregious breaches of the law. But if you're not using the highest amount and sending a message, how deterrent is the penalty regime there? And that's something that needs to be reviewed. The penalty regime needs to be looked at more carefully because we need to have basis why we are picking these amounts of penalties. So for example, more recently, actually this year, in October 2014, New Zealand just issued a report on pecuniary penalties and the amount that should be imposed and so on. And this was a step forward because they looked at all the pecuniary penalty regimes and the different legislation and so on, and they tried to assess how does the penalty regime actually work and how should it be implemented. And this is something I believe that we need to look at more closely. In addition to that, pecuniary penalties are not just, the penalties should not just be on corporations, they should also be on individuals because individuals are the ones that are making the decision the corporation end up doing. And we have now disqualification orders, but these should be used more often. If a corporation is breaching Section 46, is found in breach, then why aren't officers being disqualified? And maybe not just under Section 46, but also under breaches of the Corporations Act legislation. Another thing is enforceable undertaking is another sanction that is available. And this is a good sanction because this allows, and maybe it will be on the softer approach, but it allows for a change of a compliance culture of an organization because that's one of the aims of an enforceable undertaking. Now, so if you can change the compliance culture of an organization, then that's what you need to do to actually deal with the source of the problem. Now, of course, there is concern about how effective enforceable undertaking is in changing the compliance culture of an organization. But it is one way to actually deal with the problem. Thank you.
Thank you. I'm sorry to...
Sorry. Yep, I went out. That's fine.
To rush you. But there will be plenty of time for you to ask questions of Marina after the 4 participants. Brent.
Let me see if I can conquer the technology. All right. Thanks. I've been asked to speak about what the draft report says or does not say about cartels in the context of Part 4 of the Act. This is a very large subject, and there are a lot of things said about cartels in the draft report, a lot of recommendations, a lot of useful recommendations. And I do think that there are, however, a number of issues, problems with the report, and I don't want to seem ungrateful or churlish in any way, but I, for one, would be hoping for more work to be done in the final report. I have to say I was a little disappointed by what Professor Harper said this morning about the draft report essentially being pretty close, subject to changes in position and so on, to what we're going to see at the end of the day. I think one of the problems in relation to cartels, as in relation to some other areas, is that the draft report is very high level and that there's not enough detail in there to inform the process running home through, for example, through the stage of redrafting the relevant provisions of Part 4. I should also add, however, that my own view is that the time that's been given for this review verges on farcical. The period of a year is just ludicrous given the difficulty in the span of the topics that has to be covered, and in that context it has to be said that the draft report is in itself a remarkable achievement. Now, the hotspots in Part 4, as far as cartels are concerned, are quite numerous, and in the PowerPoint that'll be available on the Centre's website if the paper hasn't already been distributed, I've set out about 8 hotspots, including complexity and running all the way through to authorisation and alternatives to authorisation. There are a number of other hotspots, at the risk of stating the obvious, including, for example, the topic of jurisdiction that Rob Nichols spoke to in his introduction before lunch today. That's obviously one further important question. There are others as well. There's no discussion, unless I'm missing something, of the related corporations exception under 44 ZZRN in the draft report. Perhaps a more remarkable omission is that there doesn't seem to be any consideration of why it is that after 4 years now, is it 4 years? 24th of July 2009, longer than that, there's no cartel prosecution. No, so all this huge exercise that many people, including yours truly and others in the room, spent a lot of time on back in 2008, 2009, very little seems to have come from it. The federal court has been working away for 4 years now, gearing up for cartel trials, and a lot of work has been put into that exercise. I've been involved in it, and it's a bit of a damp squib, to be quite frank. But anyway, coming back to the hotspots, I'd like to be selective and just talk about complexity briefly, joint ventures, well, the concept of an understanding, I'll address that. That's an important area of the draft report. Joint ventures and other collaborative activities, and authorisation and alternatives to authorisation, if we have time for that. Now, on complexity, as we all know from sad experience, doubtless, Part 4 is extremely complex in relation to the definition of the cartel prohibitions and the definition of a cartel provision under 44 ZZRD. Justice Reres at the Competition Law Conference, Chris Hodgkiss's annual conference back in May, and some of you I know were there, gave a very acerbic and, in my view, insightful paper arguing that the Competition and Consumer Act is far too complex, and that it's just riddled with unnecessary technicality, over-prescription, and other related problems. And he described the cartel provisions as a 20-page long labyrinth of Byzantine complexity that hinders workable interpretation and application by citizens, businesses, lawyers, regulators, and judges. There are some qualifications one might make to that, but basically most, I think, would be sympathetic with it. Then we have the accretion in 2011 of Part 4, Division 1A on information disclosure, unilateral information disclosure of competitively sensitive information. We have another 10 pages of convolutions. So the complexity is patent. The draft report does address in sensible ways with respect, I think, these problems or these issues of complexity. First of all, it recommends the simplification of the Competition and Consumer Act in relation to cartels and as in other areas by removing overly specified and redundant provisions. It says that the cartel prohibition should be simplified, and it refers, by way of comparison, to the simpler model that's been put forward and is now in the latest bill for amending the Commerce Act in New Zealand. That's a relatively clean-cut and simpler approach to the definition of criminal and civil cartel prohibitions. The draft report recommends, and this is an important recommendation, the repeal of Division 4.1a on unilateral disclosure of competitively sensitive information, and no one is really going to lament the passing of those 10 pages of convolutions. And lastly, there is a recommendation that the prohibitions against exclusionary provisions be repealed. And we're all, again, familiar with the complexity and uncertainty in a number of respects of Section 4D of the Act. Now, that's all on the positive side. Just being somewhat critical, obscurity, it seems to me, remains about the role of principles-based drafting, looking ahead, and also the future of what I've described in the PowerPoint as various dud concepts in the Competition and Consumer Act as far as they relate to cartels. Obscurity about the role of principle-based drafting. If you look through the draft report, this concept of principle-based drafting, which is out there alive and well and advocated by many, not even mentioned in the draft report. So what then is the expert legal panel that's going to be charged with redrafting the Act going to make of the absence of any reference to principles-based drafting? There's no mention in the draft report of the Office of Parliamentary Counsel's excellent little guide, in my view, the Developing Clearer Laws Quick Reference Guide in 2010. So from a practical standpoint, it seems to me much more detail needs to be in the final report about the approach, the drafting instructions essentially, that should guide or direct the work of the expert legal panel when it comes to redraft the Act. On dud concepts, everyone has their own favourites or hates here. One of my pet hates is the concept of purpose of a provision, which appears in many of the cartel prohibitions and related provisions in the Act. Purpose of a provision, whose purpose is it? According to the C7 case in the full federal court, the purpose is the intention of the party responsible for introducing the provision into the contract arrangement or understanding. Well, who knows what that means in many cases that arise in practice, and why, more importantly, more fundamentally, why do we have to have this concept of purpose of a provision at all, instead of, one standard suggestion is the concept of the objective or the object of a provision, which is not a subjective concept but refers to the thrust and the meaning of the provision, or in the criminal context, the concept of intention as distinct, the intention of a party as distinct from the purpose of a provision. Anyway, enough of the complexity story. On to understanding, commitment and information exchanges. As we all know, the concept of an understanding in the cartel provisions and also in Section 45 has given rise to quite a lot of difficulty, given the interpretation of the courts that an understanding requires this element of a commitment. A hope or an expectation is not enough. There must be this element of commitment present before there can be an understanding between two or more competitors. This is difficult to prove in many cases, and it's also subject to evasion. There are a number of stories that I'm sure many people in the room have got about this, the way in which people in business have been schooled by some advisors as to what to say if they're the subject of an investigation by the ACCC. I won't go through any of those experiences that I've had in investigations, but it's fairly easy for people so minded to get round the cartel prohibitions by just being very careful about what they say, both when they're talking to competitors and also in what they say subsequently in investigations by the ACCC, to make it clear that they might have had a hope or an expectation, but they've stopped short of this element of commitment. It is, in my view, quite a rort. It's a loophole in the law that needs to be plugged. And an attempt was made to plug it, as we all know, in Division 1A of Part 4 of the Act. The draft report recommends the repeal of Part 4 of Division 1A for a number of reasons, including its complexity, and there are a number of other policy objections as well. That's a very positive part of the draft report, in my view, and it argues that Section 45 ought to be expanded to cover concerted practices, the concept taken from EU competition law, which has been out there for, was it 4 or so decades or more, and it argues that the concept of a concerted practice should be included in Section 45 SLC cases, and it defines it to mean a regular and deliberate activity undertaken by 2 or more firms. It seems to me that the treatment of concerted practice is unsatisfactory in the draft report for 2 main reasons. First of all, the definition that's proposed isn't consistent with EU competition law, this idea of a regular and deliberate activity. I don't know where they got that from, but it's not consistent with a number of cases that recognise that you can have one-off, as distinct from regular, exchanges of information between competitors, like as in the T-Mobile case in 2009. The second problem with the treatment of concerted practices is that it's limited to Section 45 SLC cases. Well, why? This is not the context in which the concept of concerted practices is used under European competition law, under Article 101. It applies to per se cartel cases, and why shouldn't the same apply in Australia in relation to the civil cartel prohibitions as distinct from the cartel offences? Maybe going too far to import the concept of a concerted practice in relation to cartel offences as distinct from the civil cartel prohibitions. Now I'll move on quickly to joint ventures. I'll just be mercifully brief. Joint ventures and other collaborative activities. The present exceptions for joint ventures in the present exceptions, as we know all too well, are a bit of a shambles in Australia. There are 6 joint venture related exemptions altogether at present. None of them are well defined. and the draft report does recognise the need to rationalise and to amend these joint venture exceptions, and that will involve in part the repeal of the joint venture or related exemptions in Part 4, Division 1A, will also entail the repeal of the joint venture defence under Section 76C. If exclusionary provisions go, so too will that joint venture defence under 76C. And it refers in passing to the NZ collaborative activity exemption that's been recommended in the proposed amendments to the Commerce Act in New Zealand. That New Zealand proposal is relatively straightforward. It's commanded widespread support amongst in the business community and amongst the legal profession in New Zealand. The difficulty with the what's said about it in the draft report, it seems to me, is that the discussion's far too wishy-washy. The panel sits on the fence. It doesn't say whether or not it wants something like the collaborative activity exemption under the proposed New Zealand legislation. It says that the New Zealand amendment may be too broad without telling us in what respects conceivably it is too broad. Singularly unhelpful from the standpoint of, for example, the expert legal panel that's going to redraft the CCA in due course. So that just goes back to my initial point about the need for better writing instructions to be given to the expert legal panel and to everyone on a number of these key issues like the future of joint venture and related exceptions. I'll come to a conclusion. Yeah, good. There are quite a few other bullet points in my presentation that will hopefully sort of convey a sense of what I see as some significant limitations of the draft report. But finally, there are obviously many useful recommendations in the draft report. Some significant issues haven't been adequately resolved. Concerted practices, the joint venture and related exemptions. Some recommendations are problematic. Well, there are a number of recommendations that are I think quite difficult, like the concerted practices one. The recent second round of submissions, obviously likely to assist, and I was stunned to hear that there was something like 500 or more of these that Professor Harper mentioned this morning. Just as an outsider in this process, I mean, it is remarkable just how much intellectual effort and how much experience has been captured by all the submissions that have been made in response to the issues paper and now more recently. But lastly, looking ahead, will the future be tense? Just how detailed will the final report be? Not very promising, what Professor Harper, in my view, said this morning. It seems to me much more detail is needed. Second point, much will depend on the extent of take-up by government, Treasury, the states, one of the issues that Fred Hilmer and others discussed in the panel during lunch. The third one, the proclivity for tinkering with Part 4 of the Act over the past decade may, one suspects, continue. Is there going to be, in fact, this expert legal panel, or will the drafting be delegated to Treasury? Tinkering, a risk. And lastly, will the implementation process be transparent? There are some good and useful things said in the draft report that are designed to achieve transparency in the process of implementing the recommendations of the draft report, but it all depends, it seems to me, on whether or not those recommendations will be adopted by the government or whether we'll be left ultimately with a non-transparent process of the kind that we had in the context of the various stages of the 2009 amendments on cartels, and more recently even in relation to price signalling. So, good luck.
Thanks very much. We'll move on to our next speaker.
Oh, hi. Prudence Smith, you will have Nick Taylor in your pack, and I'm sorry, and he expresses his very sincere apologies. A client emergency sent me up, so this morning I was having breakfast with new summer clerks and have been asked to present today. So please bear with me while I present someone else's presentation. Together, Nick and I, with former Professor Alan Fells, produced a draft new bill that should be in your pack, and that was presented to Professor Harper. We've also published that bill. There we go. So in our brief time, we're just going to look at the simplification bill that we have proposed and briefly look at some of the points that we have outlined. There is an article that's been produced that better outlines those proposals. We are particularly at Jones Day interested in the exposure that individuals, not just directors, but also frontline employees of large organisations have to penalties, including criminal penalties, and we will discuss that. And Nick's thought bubbles regarding penalties, and I'll do my very best to articulate those for you. There we go. Yeah, is it okay for you?
Yeah.
Yeah, okay. Firstly, we obviously need to look at why we're looking at a simplification. Society generally needs its laws to be complied with, but in the state that we find the Part 4 and its related provisions, the complexity leads to in our view, lower level of compliance in a number of ways. Complexity increases the cost of obtaining legal advice, and it's rational to expect that some businesses will be unwilling or unable to afford that legal advice to fully understand the law and comply with it, leaving them exposed. To the extent that business people do seek advice, that advice may be low level and insufficient, or they may adopt a conservative approach which delivers a detriment in that they're not actually competing vigorously for fear of tipping the per se provisions. Just having a look at the Australian competition laws in contrast to those of the rest of the world. Australia, just looking at Part 4, not including Section 50 or Section 50A, totals over 20,210 words, 11,201 words in the civil non-cartel provisions, and the civil and criminal cartel provisions numbering just shy of 9,000 words. Contrasting that with New Zealand, obviously without the cartel provisions, at 4,362 words. The UK has 2,700 words for its general provisions, and the Enterprise Act for the criminal cartel provisions just shy of 800 words. The US Sherman and Clayton Acts bring it to 1,400 words. India's doing better with just under 1,200 words. China, 830, and the European Union in Articles 101, 102 of the treaty is at 408 words. This is a very crude calculation. We could sit going through the Clayton Act particularly and try and identify the difference between processes and prohibitions, but having a look at that bar chart, it's hard to deny that the close to 74 pages of legislation are leaving our business community quite exposed to some complex prohibitions. Okay. Many of the provisions in Part 4 require a contract arrangement or understanding. As Brent has addressed, the focus on the statutory interpretation of agreement needs to be looked at. We have proposed that a concerted practice be inserted. That concerted practice is probably not the same as the one that the draft is looking at. We've taken, and this is where Nick would actually talk to you a bit more about the European exposure, but we have proposed wording that allows the courts to have a look more at the competition effects and the actual underlying results of the conduct by proposing that the concerted practice be defined as between two parties, including that conduct where there is no reasonable explanation for the conduct other than an agreement, drawing on rule of reason decisions in the United States. In our proposed draft, we propose that where the conduct relates to dealings between two competitors, and that would be currently sitting within 47, 45 or the cartel provisions, those could be brought into one provision, dealing with the fact that it doesn't matter where in the supply chain those agreements relate to, that the effect of the conduct is the focus of the court's decision. In bringing those words down to a simple prohibition, we were removing the per se prohibition on exclusionary dealings, removing the entirety of section 47 and bringing them into the SLC test under the new 45, removing the explicit prohibition regarding refusals to deal, removing the prohibitions regarding covenants in section 45 capital B and C. And we do propose that the simplification would be assisted by simply adopting those proposals identified in New Zealand. By co-locating the multi-party conduct, it focuses the law on what the law should be addressing, right, which is the competitively detrimental conduct, no matter the characterisation or the relationship between the parties to the interaction. The provisions addressing vertical relationships are simply multi-party interactions where the question of effect should be the focus of the prohibition. The focus on the form of the relationship and the particulars of the parties' dealings, whether they be in a contract arrangement or understanding, have to date offered well-advised parties an opportunity to navigate their way around and away from the application of the prohibitions and their application. Driving a thing is obviously not my calling. All right. Jones Day has made a submission, and a further submission after the draft with respect to the proposal by Harper to leave the per se offence with respect to resale price maintenance. Having regard to international practice in the United States where the rule of reasonableness is applied, Canada has recognised that resale price maintenance in circumstances particularly relating to prestige brands has some benefit dealing with the free rider issues and has removed the criminal prohibition. Singapore has actually not sought to address resale price maintenance at all, and the European community has guidelines dealing with prestige brands under resale price maintenance. Our prohibition deals, our simplification deals with removing the prohibition on resale price maintenance, in particular getting rid of the explicit and long provisions over 4 or 5 pages as the conduct falling within resale price maintenance. Our second submission to the draft has supported Harper's suggestion that perhaps a notification process might better suit the business community, but we would again be very supportive of removing the per se offence nature to resale price maintenance. In simplifying the Act and bringing the words down, we would suggest merger factors are better suited for guidelines, and the Australian regulator has one of the smallest amount of guidelines compared to their fellow regulators in Europe and the United States. There is a better place for those merger factors to be addressed, and Section 50A could be removed, although we do note that New Zealand's proposing 47A to mirror 50A, so they're seeing some benefit in that provision. Again, the secondary boycotts may be simplified by some drafting changes, but in recognition of at least the current government's commitment to those provisions, that the draft bill that you have with you allows those to be stay in place. I was going to talk a little bit about the misuse of market power, but I guess that we've probably exhausted that particular issue. We might move on. Suffice to say that Jones Day and Professor Fell support the introduction of an effects test, mostly in recognising international practice, incorporating the competition policy goals of allowing innovative and competitive conduct to take place. We would suggest that the conduct be authorised and that the purpose elements that are sitting in the current provision be relevant to a determination of penalties, or may actually be a base upon which an authorisation may be deemed to have not been in place. Okay. With respect to individuals, Jones Day has made submissions on the fact that the exposure to individuals is really quite out of step with international approaches. Individuals, not just as I note company officers, but any person involved in conduct is exposed not just to exposure for hardcore cartel violations, but also for contraventions of the prohibition that require competition tests to be applied. In our submission to the Harper Review, we identified that an individual in a small market in a regional part of Australia may be simply seeking to increase their own dealings with their clients and not realising that their client is operating in a different market and causes an SLC to happen at that other market level. Exposing individuals in this way puts them at a significant danger, given they could lose a house over their conduct. They're exposed to liability for substantial civil penalties following a civil trial and a decision that's based on a balance of probabilities test. Companies are prohibited from indemnifying business executives, which places these executives under excessive pressure to make concessions. As the provision is currently drafted, it is questionable as to whether these individuals could be indemnified where no cause of action is found by the court. With respect to 155, the privilege against self-incrimination, which Australia is bound under international treaties to accord individuals and which applies in the common law, is abrogated under section 155 and is replaced with an adequate prohibition against the use of self-incriminatory information only in criminal proceedings. Of course, the ACCC is able to use that material in civil proceedings. The substantive provisions are drafted in a manner that is unnecessarily and unreasonably complex when applied to individuals who do not typically have the benefit of substantial teams of advisors, as major corporations often do. And on the last matters, Australia's position is unique with respect to an abuse of dominance or a misuse of market power provision. There's a chilling effect on the competition and innovation, and as noticed, this is contrary to the US and EU approaches. There is a question about whether it is appropriate that all competition provisions attract a penalty for individuals, and are penalties appropriate when the evidentiary burden is placed on the balance of probabilities. Thanks.